I show you how deep the rabbit hole goes.
Like you, be strong to hold the powers of the sun.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And in this episode, we're going to go over alternative perpetrators, and I'm going to give you my opinion who I feel like the alternative perpetrator in the case could be, and we will just have to see what the defense proffers as far as alternate perpetrator evidence. Remember, tomorrow is the pre-trial conference, the last scheduled hearing before the trial. Now, I firmly believe there'll be more motions and we'll have more hearings, but as of right now, that is the only one that's scheduled. So it really could be the last one. And it looks like we are going to get to see it. So I'm going to try to stream that thing and be on there with you tomorrow for those that want to participate. But in this episode, I want to go through and be true to my investigation. And I've taken some of my old work and I have put it together to show you clearly why I feel like this is the alternative perpetrator, who it is. And let me just say this. This is my opinion. Okay, this is my opinion based on my investigation into this case. Listen to this with the mindset of this is a fairy tale, because I am going to be using real places, real times, real dates, real people, but it is strictly my opinion, and I'm not here to slander anyone, but I want everybody out there to understand Pav's position on the investigation.
In Idaho, an alternate perpetrator must have either direct or circumstantial evidence to meet the rules of Meister. Strong evidence would mean the perp would have motive, means opportunity.
Bryan Kohberger and team were in court again, as well as the state, and the point of this hearing was to determine whether a future hearing would be sealed or public. Generally speaking, the state is arguing it should be sealed for all of the same arguments we've seen in every motion to seal documents. The defense is arguing it shouldn't be sealed because the public has a right to know, and this is about Bryan Kohberger's fair trial, and the public has a right to know the context and not have the wool pulled over their eyes. And the public has a right to know the context and not have the wool pulled over their eyes.
First, we have to understand this and the relationships between all of these individuals and the years it must have taken to establish those relationships. Now, we can't possibly know all of the relationships that intertwined in this Coeur d'Alene community, but we certainly have identified the ones that pertain to the case of the Idaho 4. First, an important recap on the father, Mr. B.M. Remember, in 2020, he was arrested. 2 counts of possession of a controlled substance, METH, with intent to deliver. Each one of those counts are punishable for up to 0 to life imprisonment. Now, he was sentenced on 9/16 of 2020 to 2 years probation in the drug court program. So what does he do? He immediately turns around the following day and gets arrested for paraphernalia with intent to use and possession of Mary Jane. You can see on 9/17/2020, the day after he's sentenced to drug court probation. Now, what happened? They revoked his probation and then resentenced him and gave him another chance. They also sent him to treatment for an indeterminate amount of days. So you can see his probation was reinstated on 4/12 of 21, and then it was extended through 4/12 of 2023. Take note of these yellow date boxes I'm putting on all of these because they're going to be important here in just a minute. Now, as we learned in the video yesterday, he just couldn't keep it together. On 3/17 of 2022, he and his wife were arrested. And it wasn't even a major charge. It was a misdemeanor charge of drug paraphernalia with intent to use. However, because he was on drug court probation, he had already violated once. This was his second arrest after being put on drug court. Now it gets serious for him. And you can see in this record, in his records, that it lists this arrest. However, it doesn't have anything about him in the actual record on the arrest. There's only one way that could happen. But now something else has happened. Now his wife has been arrested and received a charge. And she has now been put on probation for that charge for a period of 2 years. He somehow keeps his name off the record because he is currently sentenced to drug court. And how can he do that? But come June, the situation hits critical mass because now you can bet, because he quit transporting narcotics due to the situation that he was in, he now has his wife doing it, and she is arrested for possession with intent to deliver, METH. Same charge he had, except now she's already on probation. So it is getting very serious for them. Now, the only thing that can help them is the drug task force, I assure you. So from this point, it's literally like reading a storyboard. On August 16th, 2022, she was arraigned on those serious charges. August 17th, 2022, the notice of hearing, a pretrial conference and jury trial has been set. You can bet the drug task force has so much pressure on her and him at this point that they are about to break. But then everything turned out okay. On 9/7 of 2022, judgment of dismissal of count 3. 9/9 of 2022, dismissed count 2, the possession with intent to deliver, and sentenced to probation. So it all just magically worked out, right? So remember, I told you to keep note of those little yellow boxes on each one of those slides because it literally reads like a storyboard. 9/16, BM sentenced to drug court. 4/12, he's resentenced to drug court because he got arrested. 5/2, he's hidden from a record that he was arrested on, but now his wife is sentenced to probation. 6/3, the very next month, his wife is arrested again. 8/17, a jury trial was set in his wife's case. But then 20 days later, the deal is done. Charges are dropped. She's back on probation. What happened between 8/17 and 9/7? Anything we can think of?
New twist in the murders of 4 University of Idaho students. Police are now saying that they are not sure if the victims were targeted. Walking back statements from prosecutors about the investigation. The shift comes after people across Idaho gathered for emotional vigils to honor the 4 students who were lost. NBC News correspondent Morgan Chesky joins us now from Moscow, Idaho. So, Morgan, this is the second key detail about that case that has kind of changed. Early on, police said there was no threat to the community in the first few days, and then they said, well, wait, maybe there is. And now they seem to be walking back another detail. Can you explain?
Yeah, Kate, I think a lot of the confusion surrounding this targeted statement stemmed from the fact that when the prosecutor said that it could be location-based and not individual-based, that got a lot of people thinking that it had shifted the direction of the investigation.
We tracked the arrest that pertains to the Idaho 4 case for the mama of one of the victims back to August 12th, 2021. Much like the others, it is a possession of a controlled substance with intent to deliver. And once again, that carries a 0 to life term of imprisonment. Now, 8/12/21, follow the dates on this one. Again, it's like watching time-lapse photography. Then on October 25th, 2021, she had a status conference scheduled. You can see that she failed to appear for that status conference, and a bench warrant for failure to appear was issued for her arrest. Again, that was October 25th, 2021. She disappeared, and law enforcement didn't catch up to her until the next year. But come August 19th, 2022, she was arrested in Spokane, Washington on that bench warrant. And then August 19th, 2022, she was transferred to the custody order of the sheriff to be transported from Spokane, Washington, back to the jail in Coeur d'Alene. Now, it's unclear what happened between 8/19/2022 when she was in the custody of the sheriff and her next status conference in court in Coeur d'Alene. Now, you got to understand at this point, she is facing serious charges for possession with intent to deliver with a serious history, and she failed to appear for her court appearance and has been missing for almost a year. The pressure that the task force would be putting on her at this time would be immense, just like the other folks. But nobody worry, because everything turned out just fine. On September 6, 2022, they allowed her to change her plea to guilty. They reduced all of her charges and had her scheduled to be sentenced to probation. And it's oddly the exact same agreement that was made to the other parents in the case. So everything worked out fine. But once again, this thing's like reading a storyboard. On August 12, 2021, she is arrested. On October 5th, 2021, 2 months later, she fails to appear for her court appearance and they issued a warrant. She literally disappeared for almost a year before she is arrested on August 19th on that warrant in Spokane, Washington. They release her to the custody of the sheriff, first on the same day. And then sometime between 8/19 and September 7th, something magic happened and her charges were reduced and she was set to be sentenced to probation. Wow. So once again, when we look at the storyboard, 8/19, she's transferred into the custody of the sheriff and the drug task force. And then between 8/19 and 9/7 on 8/30, we have TF and TR arrested in Moscow for trafficking. And then, strangely enough, she is offered a wonderful deal to where she doesn't serve any jail time. But you know what? I guess we could look at it as good news for her and the father and the stepmother, because they avoided prison time and seems to have gotten away with it. And everybody can say, well, Pavarotti, you can't prove anything happened because of that.
It only takes one moment, 1 minute, one night for lives to be turned upside down.
So it almost seems like setting their associates here up was pretty much a team effort, because you can see that on 8/30, just 11 days after she was caught and transferred into the custody of the sheriff and the drug task force, her associates were arrested making a trip from Coeur d'Alene down to Julietta in Moscow on 8/30/2022 for trafficking.
Was there a confidential informant that came in and went into the house and checked things out that we don't know their name? And I believe that the answer to that question is yes.
Confidential sources coming out of woodwork at the last minute. This is going to be an interesting trial.
Oh, very. Well, I'm trying to think what role a confidential source could have in this case. How could one be even tangentially connected to this case? And all I could think is that there is a potential defense line of argument that this house was allegedly somehow connected to drugs or drug dealers. And maybe there's a witness who's going to say that.
Yes. I mean, I think that's an area that they're pursuing. I know the defense has spent a lot of time trying to build up the drug case. But I've also heard, though, in the autopsies, they found no evidence of any drugs in the system of any of the 4 young kids that were killed, that were murdered. But is there a drug angle there? Is one of the surviving people who were in the house, the 2 young women, is she going to be this confidential source? This remains to be seen. The father of Kayla Goncalves has been searching for this confidential source. And at one point, his lawyer, according to what he's told people, received a letter from the FBI telling him not to intervene to look for this confidential source or it could disrupt the case.
The result of those parents' plea deal was this arrest in Moscow of Farley and Rhodes on August 30th of 2022. You see, the charges that they were being charged with were of no small account. They're being charged with trafficking over 400 grams. In Idaho, I pulled the statute, and it is a mandatory minimum fixed term of imprisonment of at least 10 years and a fine not less than $25,000 if you are convicted of trafficking over 400 grams. So This is not something a judge can reduce a sentence on. It's a mandatory sentence set forth by the legislature. The charges against these two are very, very serious. So when a order of release on his own recognizances was ordered by Judge Megan Marshall on September 23rd, 2022, I was really perplexed how they could release a guy who has an extensive criminal history and is in jail on trafficking that carries a sentence equivalent with unaliving somebody, how they can just release him on his own recognizances to go and visit a sick relative. I mean, it had to involve decisions from his public defender, Catherine Mary Mabbitt, the prosecutor, Bill Thompson, as well as Judge Megan Marshall. And then after a considerable time investigating, we learned that it was likely a familial connection to powerful people in town. You see, his uncle, Germer, who he works for, is best friends with Scott Green, who is in charge of the university and is also friends with Bill Thompson, and I'm sure possesses power that he can exercise over Bill and Judge Megan Marshall. It's connections like this that get you released on a furlough to go visit a sick relative, even with those types of charges. Now, the sick relative that he was being released to go see was his father, Thumper, who was very ill at the time, and his family felt that it was getting close to that time, so they gathered everybody together to be with Thumper. He did pull through and didn't pass away until later the next year, but you can bet this was a family event that they did not want to miss. What they couldn't have known is with a family event like this, it would draw in likely all the family, including his uncle, his cousin of the drug task force, and even his son-in-law. Unfortunately, this would be the prime place for somebody who would know exactly who set up Tyson to inform him of who set him up at a family event such as this. And it's likely that happened because of what happened next. You see, instead of returning like he was supposed to, they had to issue a warrant for him because he absconded and did not return. In fact, they didn't get back a hold of till after he was arrested in Spokane 9 days after the atrocity on King Road. So where did he go while he was absconded? Well, it's my assumption that he would go directly to see his boss, the guy that he was delivering the narcotics to, and inform him of his newfound information of why he was arrested and lost his shipment. Unfortunately, his boss is Aryan Knight down in Julietta. And that's where the atrocity really got set in motion. It was the meeting between these two in Julietta after he garnered his information from his family visit. But how does he become the informant in the Kohberger case? Well, he was arrested, you can see, actually on November 22nd in Spokane, and then he was transferred back to the Latah County Jail. You'll see the custody order of the sheriff on December 1st, 2022. That is the date that he is returned to the jail, and we need to pay close attention to the dates going forward because they are very critical to the Bryan Kohberger case. Now, there was an event in Pullman, Washington that set a lot of things in this case in motion. And that was on December 14th in the late night hours, possibly the early morning hours of December 15th. It really can't be determined. And that's when the Pullman SWAT team took out Brent Kopaka at the Coffee House Apartments. And why is this so important to the case? Keep in mind, this happened late December 14th, early morning December 15th. Now, when you have a case for trafficking, these types of cases can take up to years to prosecute. They're never completed in a swift manner. However, you can see already on December 15th, out of nowhere, his preliminary hearing was waived, and he was bound over to John Judge in district court on his charges. Less than 2 weeks after he arrived in Latah County, just out of nowhere on the 15th, they decided to waive a hearing and bind him over. I wonder what happened on the 15th to rush to this waived preliminary hearing. I mean, it never even took place. They just waived it out of nowhere. I wonder if it had something to do with the Kopaka incident. Then, in the fastest turn of events in judicial history, just 4 days later, his arraignment was held in district court. Parties present were his public defender, Catherine Mary Mabbitt, the prosecutor, Bill Thompson, himself, and Judge John Judge. They were all present at that arraignment on the 19th. Now, what were the results from that arraignment, I wonder? Well, you can see what I refer to as the deal of the century was all agreed upon. And you can see December 20th, 2022, change of plea. That's when the deal went down. You'll see down here, 2020, the Rule 11 plea agreement was agreed to. And then they set off sentencing until March of 2023, where they dismissed count 1 and 3 of the criminal information. And you can see on March 14th, a judgment of conviction and an order of probation was issued for Farley. So a 10-year minimum sentence turns into probation in a record amount of time. But folks, it's this right here that's going to get you. And that's the fact that they had to put in the court record this Rule 11 plea agreement. What is this Rule 11 plea agreement? And is it really something that they would offer to a confidential informant? Well, whether a confidential informant in Idaho makes a Rule 11 plea deal depends on a number of factors, including the severity of the charges, the judge, and the prosecutor. So for a confidential informant to make a Rule 11 plea deal, that means the judge and the prosecutor are compliant with it, which is very rare, I would imagine. Let's read. What is a Rule 11 plea agreement? And FAQ, FAQ, what is a Rule 11 plea agreement? I often get questions about what a Rule 11 is and who is eligible to receive one. A Rule 11 plea agreement is a binding plea agreement. It is an agreement entered into by the parties for a certain sentence if the defendant pleads guilty to a specific criminal charge. A plea agreement under this rule binds the court to the terms of the agreement. In other words, the judge cannot add, subtract, or alter the terms of a Rule 11 agreement. This differs from a non-binding agreement where the parties would each argue for the sentence they feel is appropriate and the judge would make the final determination. However, the court may be bound by the terms of a Rule 11 agreement, but is not bound to accept the agreement. It has the power to accept or reject the agreement. So John Judge could have rejected that. If the plea is rejected by the court, any admission made by the defendant as part of the plea agreement will be withdrawn and will not be held against them in future proceedings. The defendant can then decide to proceed forward to trial or enter into a non-binding plea agreement. Now, there are pros and cons to Rule 11 agreements. The most obvious benefit is having the ability to negotiate your sentence without the risk that a judge will sentence you to something more severe after you have already admitted to the crime. Additionally, most people are comforted when they know what your sentence is going to be prior to appearing before the judge. Last, if you do not get the sentence you agreed upon, then you can withdraw your guilty plea and continue on to trial. On the other hand, in non-binding plea agreements, the parties often come to a resolution that involves the prosecution limiting their recommendation to a certain sentence, but allowing the defense to argue for less. In these instances, you may be able to convince the judge to order a more lenient sentence than you otherwise would have received under a Rule 11 agreement. Now, for the most part, determining who is eligible for a Rule 11 plea agreement and who is not will depend upon the judge and the severity of the charges. So it depends upon John Judge and the severity of the charges, which we're talking about drug trafficking. More often than not, Rule 11 agreements are found in misdemeanor cases, not felony cases. Occasionally, a Rule 11 agreement will be accepted in a felony matter, but most district court judges who handle felony matters will not accept Rule 11 cases, except in the rarest of instances, if at all. Some judges will not accept a Rule 11 agreement under any circumstances. And some prosecutors, Bill Thompson, will not enter into a Rule 11 agreement. In fact, certain jurisdictions around Idaho have an unwritten standing rule that Rule 11 agreements are not to be accepted, even in misdemeanor cases. So now if you were paying attention to those little green date boxes, then you'll know right where we're at. You can see he was arrested on August 30th, 2022, released on furlough September 23rd, 2022, where he absconded. And then he was arrested in Spokane, actually, on 11/22, returned to the Latah jail on December 1st. And then we've got Kopaka's unaliving on the 14th and 15th. And that's when all of a sudden his preliminary hearing was waived and he was turned over to John Judge, where he was arraigned on the 19th and then the Rule 11 plea deal on the 20th. You've got to know in the Kohberger investigation when Kohberger really popped up in the investigation, and it was after they unalived Kopaka. When you look at these dates, you know that gave information to implicate Kopaka, not Bryan Kohberger. Kohberger came as a result of association with Kopaka, and they are absolutely incorrect about the Kohberger involvement. And the reason the IGG is a red herring for the confidential informant is because the prosecution knows, and Ann Taylor at this point knows as well, and she's probably known for some time because that's why she's been trying to get the discovery on the confidential informant and their statements that were used, obviously, to get the initial warrants for Kohberger. And they want to uncover that so that they can attack informers' reliability. And the prosecution knows that as well. That's why they keep him hidden. But you can see in past docs, Mr. Kohberger has the ability to challenge the probable cause affidavits in this matter that were used to procure warrants. And she cites State versus Thompson, finding informers' reliability a relevant issue as it relates to probable cause for a wiretap. Finding informers' reliability a relevant issue as it relates to probable cause for a search. You see, the affidavit from that confidential informant assisted in getting the AT&T warrant in the beginning. And by uncovering that warrant and that statement from that confidential informant, that would allow the defense to attack the informant's reliability. And the prosecution knows this. That's why they don't want it to happen. And let me show you why it's so important. Because their confidential informant is not only unreliable due to his extensive criminal history and use of narcotics, but he is also on the record in 1999 with a charge for perjury. Provide false information to the court. That's the only way you can perjure yourself. So informant's reliability is a big deal in this one, and the prosecution knows that. And that perfect spot would be right here in between these Linda Lane apartments. I'm thinking right at the top of the stairs that goes up between these bushes right here. And somebody could perch right there for as long as they needed to and see everything they needed to see. And then when everything was done, they just simply walk back through those apartments and hop in their car and drive off, as we've seen somebody do at 4:23 a.m. But let me show you how easy it would be for somebody to perch right there and see everything they needed to see. So what we have here is what it looks like in between those Queen Road apartments. If you were to take a little stroll and walk between them at nighttime. Now, weirdly enough, this is not the night of the atrocity, but you can get a pretty good idea of what it would have looked like the night of the atrocity. And all right, folks, we'll know more tomorrow at that pretrial conference. Whether I'm right or not doesn't really matter. What matters is Bryan Kohberger getting the fairest trial that we can possibly get him. Please like and subscribe to the channel. Post your comments, thoughts, criticisms, and until next time, Pavarotti's out.